something's going down in the Kouri Richins case. Today is Wednesday, November 12th. We have quite a lot to talk about, and a lot of it is sealed. And it looks like one of the defense attorneys has an attorney that has appeared on the record. And there are multiple sealed declarations from prosecutor Brad Bloodworth. There's an OSC. It's all sealed. We're going to look at the docket together. We're going to look at the defense attorney's interview. We hadn't covered it, but the defense gave an interview. You know how Judge Beard voice feels about the media. We are going to responsibly look at what is on the docket, and we are going to put a huge question mark on I have questions, and we are going to keep an eagle eye on what is going on this docket. We have a motion to classify the state's motion for an order to show cause as private, and another motion to classify the affidavit of Brad Bloodworth as private. Orders to show cause are generally regarding, well, like the ones we're seeing in the Cardi B case, that one's over sanctions. But an order to show cause is a judicial procedural mechanism to say, hey, explain. It's literally an order to explain yourself. What we don't know is what this order to show cause is regarding. But it's what we're looking at now, because everything else that's going on, we've seen. We know that counsel got appointed for the witness, Robert Crozier. Fine. There is a sealed second affidavit of Brad Bloodworth the next day, October 21st. Defendant's reply to the state's opposition to defendant's motion to reconsider bail. We talked about all of this. There's another sealed motion to classify notice of supplemental authority in support of the state's motion for an order to show cause. That's on October 30th. We don't know what the OSC is about. But then it gets even weirder. So docket 1092 is a sealed non-public information notice of appearance of counsel. So another attorney has filed an appearance. And then this is all on Halloween. And then in quick order, we have numerous sealed documents, including appearance of counsel, notice of limited appearance for attorney Alexander Ramos. Why is an attorney appearing for defense counsel Alexander Ramos unless it is regarding the OSC? This is the reason you would want an attorney to appear. And then someone filed non-public information privilege communication, which could be a lot of things. It could be communications between attorneys. It could be attorneys and clients. But there is some type of privilege communication that is also sealed, all on the same day. Then the same day, this all went down on Halloween. There is another privilege communication motion to strike filing of appearance and remove from the court docket. So they are not just striking the appearance, they're removing it from the docket. This appearance of counsel, we still know that it's an appearance of counsel for defense counsel, but the filing has been stricken and removed from the docket. And then the court issued an order on November 3rd that's just completely private and sealed. I can only imagine that it's relating to all the stuff above. Then, also November 3rd, there is a non-public information memorandum in opposition to the motion for an order to show cause. What is happening? I don't know what the order to show cause is regarding, but it's all being filed at the same time that defense counsel is having an attorney appear on their behalf. So then, on November 7th, there is another motion to classify the state's reply in support of its order to show cause, and then they're asking the court for a decision on the order to show cause on November 7th. And it's all sealed. And all of this goes down after the defense attorney's interviews. I do not know if they are related. They are close in time. However, this is also close in time to when the defense filed all their motions regarding the witness. Could it be that it's related to that witness? Yes, it could. If witness Crozier had the conversation where he, quote unquote, recanted with Attorney Ramos that would be non-public information because that's the defense attorney talking to a witness. That's work product. And if somehow it is being alleged that the defense attorney misstated what the witness said or something, that could also be a situation where the defense attorney is like, no, bring my attorney in. So it could be related to the quote unquote recanting witness interview. It could be related to the television interview. Hey, Law Nerd. It's time to talk a little bit about making sure that your data isn't on the internet with today's sponsor, Incogni. In October, did you see the headlines about 183 million email passwords being exposed? Well, in early November, there is new reporting showing that that's actually not the case. And it was 1.3 billion unique email passwords that were exposed in what is the largest corpus of data some cyber experts have ever seen. It is not an understatement that your data is probably out there in a way that you don't want it to be, which is why we are talking about one of my favorite services, today's sponsor, Incogni. Not only do they do data removal, but they also have custom data removal where you can request data be removed from specific places. It is time to add this to the list of things that modern life requires, and making sure that your data is being removed off the internet is one of those things. So Lana, if you are ready to take back your data, you can do it with Incogni at a great discount at incogni.com/Emily to get 60% off annual plans. So just head to incogni.com/Emily and use code Emily to get 60% off annual plans. Let's get back to today's episode. October 15th, this interview was put on YouTube. I do not know if it aired locally in Utah prior to that or same day as that, 5 days before this flurry of motions with regard to the order to show cause.
Wendy Lewis, and I am lead counsel in the Kouri Richins case.
Oh, well, that clears that up.
Nestor, I am one of the attorneys on the Kouri Richins case.
Alexander Ramos, co-counsel on the Kouri Richins case.
Wendy Lewis, Kathy Nestor, and Alex Ramos took over as Richins attorneys in May of 2024 after her previous attorney declared a conflict in the case.
What we came in here today were to focus on 4 very serious areas.
They have their talking points
That have been absolutely factually reported incorrectly and that have been discussed publicly in court, in open court. I do think the prosecution has declined to correct false information that has come out in the media.
If the prosecution tried to do this and did it in a way the defense didn't like, I imagine that the prosecution would get excoriated. Your Honor, they're talking to the media. The defense is allowed to respond, and she is laying the groundwork for this. She is saying, we are not going on the offensive here. We are correcting a narrative. We're responding to things that happened in court. We're allowed to answer back. That is the way that they are going to say that this is fine. And this might not be the subject of the issue. It might be.
Media, and we've waited and hoped that that would occur, and it never has. And so that is why now, at this moment, at this time, we're coming forward and saying, well, then we're going to correct it.
The language that the prosecution uses in its filings, do you feel at any point that they have crossed the line?
Yes, this has been interesting. I have not seen the personal language in filings typically in court that we're seeing here. The prosecution does seem to have a very strong opinion on this case. Not just, here's the evidence. They seem to have a personal opinion, which I think is reflected in their pleadings and has been reported on, some more than others. The poppycock memo was one that got reported on, which is surprising and unusual.
They keep talking about things that have been reported on when we have covered this case, filing by filing almost. And there are things that I have no idea what they're talking about.
To see language like that in legal pleadings. So we've been uncomfortable with that. I see the prosecutor's job, like I said, is to fight for justice. It's not personal. It's not personal for them, and it shouldn't be personal for us either. We're all there doing our job. We're there to protect our client's rights.
Yes.
We're there to make sure our client gets a fair trial.
And they're doing that.
They're there to serve justice. And what they think is justice And what we think is justice is very often the opposite.
That's fair.
But it begins to get personal sometimes, I think, when it's a case that it is high profile, there is a lot to it. They've been working on it a very long time. And, I can see that sometimes you can't help but get personal. Sometimes we can't help but feel personally upset about our clients. It's hard. It's a job, but it's hard. Some prosecutors are better than others at not making it personal. It's just been my observation, and maybe I'll be proven wrong at some point in the future, but this has become quite personal for them.
Interesting.
So why did the defense attorneys come to 2 News Investigates? Why now? Why not just correct the record at trial?
Look, I
Why now? Why this interview?
never thought I would be sitting here. I don't think I should need to talk to the media. I really believe that I should be able to get a fair trial. But the way that this case has gone.
Oh, so you guys do want to talk to the jury pool. I would like to think we can get a fair trial, but if we can't, we'll just talk to the media now.
I don't think we can do that. We have to make sure that when we step in there in February, that we have leveled the playing field, and we can't just hope for that.
Is that why you came to me?
That's exactly why we came here. And really, it's an ethical duty. There's a rule.
Listen to what he just said. We have to level the playing field.
Is the prosecution
angles are
in this
killing me.
case injecting a false narrative to the media?
I don't know if they're necessarily injecting it, but they're certainly not correcting it. And I think that's why we're here today, is we honestly feel that we have an ethical duty when we have a client who is facing such serious charges and there is misinformation.
Did Kouri tell you she wanted you to talk to the media? Is that why it's all sealed? Is it that your client was like, you need to go do this?
Out there, and it is not being corrected. It's a disservice to justice.
And if I may ask you this, I'm not sure if you will answer, but has the Summit County Attorney's Office vilified your client?
It's not their job to either vilify or create or make them insane, but it is their job to stick with the facts. And that's something that they have not done in this case, especially with how it's been portrayed in the media. If their goal is justice, they have not lived up to it, at least in this case.
The music
I
is
asked
so
Summit
dramatic.
County Attorney Margaret Olson and Chief Prosecutor Brad Bloodworth for an on-camera interview for this report. I received the following statement. We are aware of the recent filings submitted by the defense. We will address all matters related to this case through the legal process rather than in the media. Our formal response will be part of the public record next week. We ask that this comment be included in your report to ensure our position is accurately represented and the reporting remains balanced.
Are those all the sealed documents, though? Because everything that came in the following week, there was stuff that was responding to the witnesses recanting, but then everything else is sealed. There is a lot brewing in the Kouri Richins docket. Most of it is sealed, including the prosecution's request for an order to show cause. Remember, that is the order to explain. We don't know exactly what is going to be explained, but we do know that Defense Attorney Ramos has an attorney that has filed an appearance on the docket, and then that appearance was made completely sealed and all the documents were taken off of the docket, but the title stands. That could be related to conversations Attorney Ramos had with Kouri Richins, because there are privileged communications. It could deal with the quote unquote recanting witness. If Ramos is the one that sat down with the witness who said, no, I never told law enforcement it was fentanyl, but that's not true. If that statement was only given to Attorney Ramos and there is something up with that, Attorney Ramos could have become a witness in this case if he was the only one that talked to that witness. That could cause a problem. This interview could cause a problem. The court has been very clear about limiting media in this case, and the 3 defense attorneys are like, we have to clarify this. It could be an issue with the recanting witness. It could be an issue with the interview. We don't know. But if Attorney Ramos has become a witness in this case, we will see that play out. We have multiple affidavits from the prosecutor, Bloodworth, that are sealed. We have an order to show cause motion. We have an objection. We have a response, and they're asking the court to give a ruling on it. And everything that the court seemingly has said about that has been sealed. So at some point we might get the information. So asterisk this, because I really want to know. The judge is not going to be happy with this TV interview after the defense made their motion for change of venue, had an entire investigation into the change of venue, and used the same firm that was used in the Kohberger case. On the docket, we see, as we're getting into early November, they recently filed a transcript regarding the change of venue. The change of venue has been denied. The appeal on the change of venue was not taken up. Why is it coming back up now? And is it because of this interview? The defense was very unhappy with the ruling on the change of venue. And now there's this media interview. And now all of a sudden, the change of venue was April 7th, 2025. Why is the transcript of that being filed on the court docket November 7th? And is it because of this interview? What is the defense asking for? Why does defense attorney have an attorney appearing on the record? What is this order to show cause about? And what's the fallout from this going to be? Trial is supposed to begin in February. And it took them quite a while to get that trial date because the defense counsel had a federal trial going right before it. They were trying to move that trial date so that it didn't conflict with ski week and it didn't conflict with spring break. And they were trying to wedge it in between those two things to not inconvenience the jurors. There is no next court date on the record for hearings on these motions. And if there are hearings on these, I wonder if they'll be sealed. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.